So a year ago, I had the great opportunity to talk to somebody who worked in the court in Philadelphia, Pennsylvania, by coincidence, birthplace of both my parents and where they were married, and to get an insight into what life is like on the inside. And here we are a year later with Andre, who has now left working full-time at the court and can give us some lessons learned and an update on what he has in the probate from the court employee side of this. Andre, thank you so much for joining us today.
Bill, it is an absolute pleasure. I want to say when I was getting ready, just as a very interesting tidbit, when I was getting ready to leave the court, one of my interviewers had actually saw the interview that you and I did, and she thought very highly of it. And so I want to thank you for that. And you know, it's crazy how these things come around full circle. So when I was ready to leave, I was applying to jobs, and somebody Googled me or saw probate or election, Andre Desir probate or probate law, and our first interview came up, and it colored me in a favorable light. So thank you for that. And I thought you'd like to know that.
Well, it's my pleasure. And you've also inspired other people. I all the time try to teach real estate agents looking to expand a probate, go to court, meet people. It's different in LA. It's very anonymous and structured and distant. But in most jurisdictions, if you can meet the court personnel, you have a real advantage to offer your clients. And I have at least one in particular that comes to mind of an agent who went to court, met people, and as a result has really become almost a celebrity in his county court because he does bring good value to the customers as well as to the staff. So let's talk a little bit about what was your role. Now you left recently, but what was your role when you worked for the courthouse in Philadelphia?
So I was a law clerk to two trial court judges. And so they were they were the arbiters in probate. So the trial court judges in Pennsylvania, the Court of Common Pleas, they're vested with all the powers, so they can title property to somebody, or they could put somebody in prison. They have all of the full authority and scope and power of a judge in Pennsylvania.
I always tell people a judge can do whatever they want, so be careful what you say. So you were a clerk, but you were a member of the bar. You went to law school and that. So in LA County, we would refer to you as a probate attorney, not as the client's probate attorney, but as the court's probate attorney. So you helped vet things for the judges. You pre-screened documents and recommended what their decision should be.
Yeah, and it's very interesting that you say that, because when I first started, I was very aware of not trying to substitute my own judgment for theirs. So I would always tee up things like, just prepare all the files, and here you go, judge, here's all the files, here's the case law, here's the outlines. I would never make a recommendation. I would just provide all of the information in a succinct fashion for them to make a decision. And very, very early on, I got disabused of that notion, and I was told that I always needed to come with a recommendation. Their minds are their own, and I took that for granted. And they always it helped me, trained me to be a better lawyer. And part of that was sometimes they miss things or they see things differently, and they want your perspective on it. Even though they've both my judges 20, 30, 40 years on the bench, they've seen it all. They would still they appreciate your perspective. So I would prepare the documents, make a recommendation on every single piece, every single filing that came in there, every case that we had. I would have to, and that recommendation would have to be supported by the law and the facts.
And in LA County, for those who follow things, we have a system. You can go online and see the notes where the probate attorney or the clerk in Andre's case, reviews the notes, outlines what's happened, and then always, I think, makes a recommendation. Now, sometimes they'll say, based on this, can't determine, but generally will make a recommendation of some sort, or sometimes the recommendation is can't make a recommendation based on lack of data. So you did that for how long?
1 year exactly. I started in May, I ended in May.
And what prepared you for that job? What did you do before you were working as the clerk in the probate court?
I worked at Grant Thornton for a year as a tax associate. And before that, in law school, I had externed for a judge in orphans court, which is what we call surrogate or probate court in Pennsylvania. So I had worked for a judge in law school in orphans court. So I had an idea of what the caseload, the case types are, some interesting things and facts about the orphans court system.
And just for the nomenclature for everybody, because this is, my following is somewhat national, different counties and states have different names, I guess, by state for the courts. Orphans court in Philadelphia includes that's where probate's can be found. I think it's family court in many other jurisdictions. In California, we have probate court, and then there are certain family matters like conservatorships and guardianships that are adjudicated in the probate court. So technically those things go to probate court as well. So you want to learn the particular nomenclature of your state and your county. So when you speak to attorneys and clients, you can speak authoritatively and efficiently. So
Bill, I think that is one of the greatest value adds you can add to the people watching your channel and your program is the nomenclature. And that was one of the things that I struggled with initially when I first started, learning the difference between what an executor is and what an administrator is. And each word means something different. If you have an executor, that means that there was letters testamentary. Somebody in a will said, I want you to handle my affairs. That is, it tells me that there was will, that it was probated, that the person in the will named an executor. That's what that one word does all in its own. If I hear the word administrator, what that tells me, there was no will, somebody applied for letters of administration or to administer an estate when, and made the allegation that there was no will for the decedent. So these words in the nomenclature, if you can learn them in your jurisdiction, in your area, it's so enlightening, and it will help you be a better, like it will make you more efficient. When you talk to people, you'll have credibility. It is the easiest thing you can do in the probate world to gain credibility and figure stuff out, is learn the terms and what they mean.
So I'll share a little trick I use for the distinction, which is execute to me is like executing a play. Like the quarterback has a play, it's drawn out, we execute that, which in our business is the will. If you have a will, you execute the will. If you don't have one, you're the administrator. It's kind of like you're the coach. You don't know what you're gonna do. You watch the quarterback, he's calling audibles, but you have the general concept of what's supposed to happen. You're administering, not executing. And then if you don't know which it is, they're the petitioner, because you don't know, do they petition to be an executor, or they petition to be administrator, or the judge hasn't decided if there is a will or not. That would be, I don't know which it is, but don't use it as a fallback. Try to use the right word, because that has implications in the processing of your probate estate. So thank you for pointing that out. And I am a little bit of a stickler when I have agents who call me all day long with different problems and attorneys situations, and I am a stickler for the words, because when you get the right word, it locks you into certain things. You get the wrong word and you get a little confused.
And I'm going to be honest with you, as someone who has extenuating experience in this field, when I hear someone say the wrong word and misunderstand or misapply the term, it raises a little, like, I have to check this person's work, right? Like I have to, it raises flags, or it lets me know that maybe you don't really understand this as well as you think you do. So it is just, it's something to think about. To gain credibility is using the correct terms in this space really makes a difference. The difference between a distribution and a disbursement, right? Like knowing that one is like an inheritance and the other is paying a bill. It is, again, it was one of the things I struggled with, but the minute I figured out that, Andre, you need to take a step back, you need to pull out the dictionary specifically to this area of the law, all weekend, you need to write these words, like do all the little things I did in elementary school, because once you figured it out, because I was tripping over them, I was using them incorrectly in the beginning, and then it would cause me to lose credibility with the judges, and I immediately put it was one of the simplest things I did that brought me the most results.
I was going to say credibility is real currency with judges, right? If they know you and know your work to be good work, you're going to get certain decisions that other people aren't. It's right at the edge, but if the judge I saw it happen over and over again in court. If the judge knows you and trusts you, they're going to give you a little bit of a leeway. Whereas if they don't, no, they're going to go by the book, and that's just how it works. So it's so important to earn that we had the opportunity. So in the last year, how open and how in person is probate court in Philadelphia compared to, I don't know what you would think beforehand, but or pre-COVID?
So during COVID, we were allowed to do all of everything was able to do online. Towards the end of the year, this Pennsylvania Supreme Court issued a directive saying that, like, business as usual, get back in the courtroom. This was in about December, early December, to be effectuated by the end of the month, that like all of the COVID protocols, all of the Zoom ones were to be held in court again, but with the small exception that they liked the Supreme Court and other courts really appreciated the ability to do incompetent hearings and competency hearings and guardianship and conservatorship matters via Zoom, because previously it was a logistical nightmare, right? Like it was, judges had all kinds of stories about riding in the back of ambulances, or somebody being a gurney being pushed into the courtroom, because the judges, before they declare someone incompetent or competent, they always had to see them. It was very important. And so there were all these stories on how to make that happen. And with the new invention of Zoom, the courts kept that going. So everything else in person, any petitions for the adjudication of incapacity, anything to do with guardianship or conservatorship, it was allowed to continue via Zoom. And in my opinion, it was the correct decision, and it makes it very amenable, very possible that those people can participate in a meaningful way in the judicial process, whereas before it was a logistical nightmare.
Now in LA County, I would say 80% of routine matters are still being done on Zoom because they allow it. And maybe 20% by choice coming into court. They, I like when I do a purchase of property, I feel like I want to be there in person to avoid any potential mistakes. I want to read the room. I want the judge to hear me, whatever. So I go for those. But I would say about 80%, maybe 90% are still done via Zoom, even though the court allows like wide open protocols. Is that the same in Philadelphia?
Almost, right? So you cannot, so we can do still some preliminary matters like a scheduling conference. If there is somebody wants to withdraw, things like very rudimentary things can still be done via Zoom. Mostly pre-trial conferences, setting schedule, scheduling orders, dates for things, that kind of thing can be done via Zoom. But anything substantive would have to be in person, with the caveat that incapacity matters could be still full scope via Zoom.
Wow. So in the course of your job, then you've seen hundreds, thousands of probate filings from attorneys. Now in LA County, when I pull the numbers and run it, 90% of the cases are done by an attorney who's done one or less in the last 12 months.
So Bill, there's an excellent program that I'm going to stub right now, and they're not paying me. It's called Law Clerk Legal, lawclerk.legal. It is a website where it's like TaskRabbit for attorneys. So you can work for other attorneys in other jurisdictions. And I've done a little bit of work in California. And I will say that the California probate code and the fiduciary code in total, it's like, I've seen across the 50 states, I've seen all of the probate codes, and California is by far, in my opinion, is the clearest, most succinct probate code. How I describe it to other people, it's like when you drive on a 2-lane bumpy road with, lights flickering and you can't really see very well at nighttime, versus like 4-lane highway, paved, LED lamps and every 5 feet. That's what it's like, in my opinion, working with the California probate code. I want to go and work in California just because the probate code, it's so very clear.
Well, yeah, the flip side is I think that the attorneys, and I see this happen all the time, who've never done any probate, assume that because it's clear, it's easy, and therefore they can take the occasional case. And excuse me, I'm gonna turn off the it's not quite that simple. Like, as clear as it is, you still have a process to go through. You still have steps, paperwork, and I also think because the process is so clear, the judges require things to be precise as well.
Bill, one of the things that, to answer your question and to talk to that point, is for some reason when attorneys, in my experience, have entered the probate arena, they forget they forget everything they've learned about the law, or they think the rules don't apply. I don't know, it's this magical place to them where things must be done differently. The rules of civil procedure still apply. The rules of evidence still apply, right? Everything still applies. And somehow they are like, oh no, I'm in probate world now. I don't have to make objections to evidence as it's entered. Or they're not quite sure can I make a motion? Can I file a motion in probate? Like, it is this, they enter the probate world and it is a conundrum to them. And I agree with you that the one-offs have caused some troubles, in my opinion, for clients, wherein attorneys come in and they don't know what they're doing. They don't know what their options are. They don't know where they are in the law, and it causes all kinds of kerfuffles.
So if you were to give advice to the probate attorneys, the professional attorneys you have seen in the industry, what's one piece of advice you'd give them, or one mistake you see that you would urge them to correct?
The rules of evidence apply. Make objections. Don't let items into evidence that there shouldn't be into evidence. I would also, a lot of the times, the local rules are and the actual rules are more important than the statute. It's are just as important as the statute. There's an interplay between the three that sometimes people overlook. Also, I also think that newer attorneys are it's like just like a general fear. I would say be confident in the space. Like even if you're wrong, just be like go in with some confidence. I've always found that newer attorneys don't have the like they're not sure if they're doing it right, and it messes them up. I don't something about that.
Hmm. I think the local rules are so critical that, and it surprises me how many attorneys don't know there are such local rules, right? And they're posted on the county website, and I've downloaded and read them. They're not that complicated. It's not as hard as the probate code. Even that section has to be read more often, but there's often very detailed rules. And if you don't follow the rule, you're gonna be told, that's the rule. Sorry, that's not gonna work. So you also see families who aren't being served well. I think you know I spoke quite a bit last time about that. That's just sometimes it's heartbreaking to see, grandma, grandpa, World War II era, bought a house, lived, modestly, paid off the house, have kids have kids, and the whole thing ends up being squandered in squabbles in probate court. What advice would you give to families that enter probate court?
There is this like there's a lot of I don't know for some reason probate, for instance, in my opinion, it disproportionately falls victim to the he said she said I heard and someone told me and I can't I don't know and it falls victim to a lot of hearsay and a lot of non-facts and not actual evidence, right? So a lot of the times people say, well, I don't know who, this person's in charge. I was just in a cab in LA just this last weekend, and this woman from Atlanta was telling me about how her grandmother's house sold, and she was told all of these things by someone else, right? I'm like, okay, did you see that in writing? Right? Did you get a copy of the account? Did you request an account? Right? So I think the number one things that families and members can do is be like, I hate to quote Ronald Reagan, shout out California, trust but verify. Yeah, it's trust but verify, right? You don't have to be, a lot of the time people, there's this feeling that like, oh, I'm being a burden, or people will, they don't want to answer questions, or there is my family, it's going to cause a rift in my family if I try to assert my rights or look to assert my rights. Whereas I think, and I found that the people who, you can do both, right? You can be kind. You can say, I'm so sorry, what's your name just died. She just passed away. We loved her so very much. By the way, when you get a chance, can you send me, a copy of the inventory that you filed with the courts? Right? And then if they don't respond to you, they don't request, put it in writing. Like, hey, Pat, just checking in. I haven't received a copy of the inventory that you filed with the courts, which is in an account or a list of all the assets of the decedent. I haven't received that. Can you please send it to me by, in the next 30 days? You put that in writing, you send it to them, you keep a copy for yourself, right? You never get anything back, right? They don't respond. They don't send you an inventory. Then you in almost every jurisdiction, there is a process by which you can compel or request that an executor or administrator provide an account of their administration, right? There are certain rules to it, like 3 months, 6 months, 9 months, it varies by jurisdiction, but there is some process by which you can request information officially from the executor or the administrator. And if you're ever, in doubt, that just request the information, right? I know it's a little hard. You got to get to the court, you got to get to the filing, you got to get to the estate. But you have a right, and you have a way to pursue that right that is important and it matters. So to the families out there, I would say get stuff in writing, get copies of ththings, request copies, make those requests in writing. Be kind, but be forceful. Like, hey, I really like to see the inventory. I really like to know, you've been administrator now for 2 years. Can you provide me an account, of your administration? No, you can't provide it, or you haven't, or they're ignoring you, or it causes tension. Here's another thing that happens. People get bogged down in feelings and emotions and all these other things, and then they somehow, the facts move right past them. Like, always focus on the facts. Oh, I'm so terrible. I understand she wanted what's her name to have this, that, and the third, and what's her name is causing ruckus over here and there, and it's terrible. By the way, can you still send me a copy of that account? Like, they get bogged down in the facts and the feelings and the emotion, and they miss the facts. Like, I need a copy of the account. I need to see what you've done. I need it in writing.
Yeah, and certain things have to be in California. It's all filed and publicly available. So when you not trust but probates. So for example, I literally had today, a family member called and said, I don't know if a probate's ever been filed, it's been a year. We gave the attorney some money. We haven't heard, he doesn't return our phone calls. I said, well, I can tell you if a probate was filed or not. Let's look up, what's the decedent's name and what's your name? And I'll look it up. And the answer is no. Magically, they call the attorney today. He's sending out paperwork to them but you can verify that information in Los Angeles County. You go online and check it. In many counties in California, bigger counties typically, you can at least verify if it's been filed or not. You can get a case number, who was the petitioner of record, who's the attorney of record, was an inventory and appraisal report filed to your point. So some of those things you can do, and I often say it's not a file. Like they can say what they want, they didn't file the paperwork, then it doesn't count, right? You can't, there's no inventory unless the court has it. That's kind of the bottom line.
And to add to that point, what I've also noticed too, sadly, is so for instance, in California, you can do a family exemption to file the account, or you can have the beneficiaries sign a waiver essentially of filing the account. And a lot of the times those things are the information is not given full scope to people. They're not saying, oh, this is in lieu of filing an account. You file this, you sign this waiver, and then I as executor administrator don't have to. They say, oh, in order for you to get a distribution or get paid out, you have to sign this waiver, right? Like I've seen that happen, and it. Yeah, I know it's one of those. It runs that like, ooh, it doesn't sit right with me, but I've seen that happen because a lot of times people don't understand the process and their rights, and they don't know what they're entitled to. And again, I want to get this point across. In every jurisdiction that I've looked in, everyone, including California, is entitled to an account of the administration of the executor. That means that in writing, they will write down how much money they've received, the property, the disbursements, what they've done during their administration. And then you can object or challenge or disagree with their account. You can say, wait a minute, you didn't sell the house for 50K. I got a copy of the Alta statement that Dave bought it for, and that doesn't match what you're saying. There is an opportunity there, and a lot of people need to just be aware of their rights. And that is the number one thing is be kind. Don't give into the he said, she said. You don't have to subscribe to being mean, but you can be, respectful in your rights. I have a right to this thing. I think I have a right. You could maybe don't have a right, but trying to pursue it and get information and not falling prey to the bully tactics. There are a lot of bully tactics in probate, and people, need to just stand up tall.
One of the areas that I've made a stand on, a little controversial, is in favor of probate advances. Now, appropriately. I look at it as a very powerful tool that can be misused, but I also have used it regularly for clients who have no money, who otherwise are going to get a bad attorney or no attorney. Instead, get an attorney, pay for their expenses, and yeah, they're giving up an extra $5,000 out of their $500,000 inheritance. But at least they're going to get it in a timely manner rather than not. That's how I look at that. I want to give you a chance in the soapbox. Tell me I'm wrong, agree with me, or find something in the middle.
You're not wrong, right? It's, to me, what it sounds like is like communism, right? In theory, the concept sounds good, but in practicality, what happens is you get these small tyrants, right? So you get your people who prey on and then these what I would call unconscionable terms. It's not $5,000 on a $500,000 inheritance. It will advance you $50,000, and we are entitled to everything that you're entitled to, right? Those are the terms that I've seen on those advances. And while I think in theory, I agree with you, it is a good idea to get poor people some money so they can do some stuff. Like, I am on board with that. But at the same time, I found that poor people fall victim most of those predatory scams because they don't have leverage, they don't have bargaining power, they don't get to say, well, no, I'm not going to take this deal, it's a terrible deal. They don't feel like they got a choice, right? So they take the deal, the $50,000, they give up $250,000 because they didn't have any money to hire an attorney to probate the estate, because it is expensive. It is expensive. Those filing fees adds up. All of the out-of-pocket expenses, the cleaning, the moving, all of those reimbursements you got to seek from the estate. You have to have the financial means to establish them.
So if I elected Andre Desir not just to Pennsylvania Congress, but you're the head of the Congress, whatever you call it in your state, and you have a chance to change probate law, and you have enough power behind you to get those laws changed, what would you propose to effectuate changing the probate law that would help families and citizens of Pennsylvania?
So in Pennsylvania, it needs to just, that's a really good question, right? So I'm getting on the soapbox here. What law would I add?
More laws, you can hit a couple, You're You won the election, you can put two things in one bill.
I would make so probate information is not accessible, or it's generally inaccessible. I would make it accessible. And what I mean by that is have a
Oh,
portal online where you can look up that information, as opposed to having to go to the Register of Wills office in the county where the person died.
we
There's a
have that in
lot of
California.
there isn't a unified system to find out if an estate has been probated. So making a connection with, so we get death certificates, right? When a death certificate is issued, maybe like some connection with the Register of Wills for that county and then when a probate is filed, something triggers like maybe a notice in the paper. Although those things are supposed to happen, the people are supposed to do them, and sometimes they don't happen. But making information more accessible to people is what I think is at the root of the problem. People don't have information, and then they make decisions off of bad information or lack of information. So making a unified system where someone dies in Pennsylvania and an estate is probated, that you can go and look that information up online. Anybody can, open to the public access, put in that person's name. And if somebody opened an estate for it, like who filed for letters, when that person died, I mean, not real, like not their social security number, but generally what happened in probate, having that information accessible to the public.
Well, we need to get in California because we have that actually online here in LA County. It varies by county how much you can access, but in LA County, I think all that's available.
Bill,
So,
I had a question for you, and I wanted to change gears real quick. So I'm looking to buy a house right now, right? I'm in Pennsylvania. My partner and I were looking to buy a house right now. The Feds just increased the basis point for the 19th time in a row. We're at 5.75%. There is a mismatch. There is a disconnect. The prices the interest rate keeps going up, meaning that the houses are going to cost more money long term to buy, and the prices are not dropping. There's no buildup of inventory in the market. It's incongruent, and I don't understand it. Help me understand it. What advice do you have for me on, my partner and I are tired of renting. We want to start building equity. We want to, purchase our first home, but we're at a point where we're like, even if we have 800 credit, 85 LTV, we still getting 6.5% rates, and it's outrageous.
so first thing I would say is there's two questions. I think one is where's the market headed long term, and second is at what point does it make sense for us to buy a house versus to continue to rent? So as far as predicting the market, I'm not one to predict the market. I'm very big on where are we now, because I don't think we're gonna default in the debt, but if we did, it'd be catastrophic. But I don't think we're going to. I don't think we're gonna have a nuclear war in Ukraine and Russia, but if we did, it would change things. I don't think we're gonna have a war with China, but I don't think our government's gonna continue to be out of control financially, but it might. I don't know the answers. You tell me the answer to those questions, I'll tell you the effect on interest rates. Today, I would say the rates have been between 6 and 7 all year. And at the levels we're at in most markets, I can't speak to Philadelphia, but in LA, for example, there's still more buyers looking for properties than there are sellers selling houses. And that's not going to change. It's not going to change at all. The interest rates make it harder for sellers to sell, because if you refinanced last year at 3.5%, to buy a new house at 6% makes it hard. That's why I'm in probate, because people, when they pass, somebody's got to sell the property, and that solves the problem. So I would give you advice, to use your advantage to try to find properties in probate. I have investors who are nervous about the probate stuff, and I say, well, look, I'm an expert in this, and I'll help you understand it. Well, you'd be the expert in your market area to understand those things. But as far as where the market's headed, I wouldn't predict that. Whether you should buy or not, I think the thing that I would say to people is buying a house is a function of your personal finances. The mistake people make is they buy a house and then they upgrade all their other lifestyle, right? Now we need new furniture. Well, now we need a better refrigerator. Well, now we need to entertain more. It's really the opposite. You got to get in the game and start off. When my wife and I started, we had nothing. We had no furniture other than a bedroom set, a dining table, and some chairs. And we saved money and eventually worked our way into what our lifestyle is now. So I would say that when I see most first-time buyers, they want to buy a nicer house than they're renting an apartment, and that's a big upgrade in your lifestyle. If you can afford it, good for you. But just know that's really why everything's doubling, is you're going from your decent 2-bedroom apartment to a 3-bedroom, 1.5 bath house with a yard. Of course, it's more expensive. It makes sense. So you have to think through the lifestyle and the changes. Now, if you can combine things, I'll give you one example. My house, I used to have an office. Now I made one of the bedrooms into an office. So I saved about $1,000 a month. I have great internet here and phone, and it's cheaper at the end of the day. We save some money. So we make all that work by living in the property. It works for us. But I think for you, I would say, buy a house when you can afford it, when it makes sense to. Don't get caught up in I have to own a property. You can own property without it being your house. You can own investment property. You can buy in other areas. You're in Philadelphia, I imagine is way more expensive than outlying areas, Lancaster and other areas that are more suitable for rentals, where there's Hershey, where there's a good job market maybe and rentals, but they're not as nice homes, but they have a higher function of rent to purchase price that make it a better investment. So I would say, don't confuse the two. The wealth of owning a house, and it's a long answer, I know, but I think for whatever reason, our political decision in California for sure, and I think nationally, is we're going to build less houses. I think it's part of the political movement of climate change, and there's a lot of reasons behind it. But at the end of the day, we're not building, we act surprised there's an affordability problem, but we're not building any new houses. So your population goes up, you're not building houses. Once you have go up in price, there's no way around that. That's just math.
I was hoping the market flipped from being a seller's market to a buyer's market,
No,
and it hasn't, and it just confunds me.
It's not going to happen. And I think people are waiting for that to happen. In my experience, you can't. One thing I learned, the smartest guy I met when I started this business said, you'll never outguess the market. And so I would say that the best time to buy a house is when it's best for you to buy a house if you can afford it, or you need to, you want to raise a family, or you want to be in a certain area, or there's a certain neighborhood, like in my case, there's a certain neighborhood that we wanted to live in, house came in the market, boom, and we've lived here for 25 years. It's been great. We raised my daughter here, and now my grandson, we're raising the neighborhood as well. But it just depends on your personal lifestyle choice, but there's never a good time. It's always a bad time. It's always expensive. You have to follow the best time for you rather than the best time for the market.
That makes sense. Well, thank you for that. I appreciate it. I was, just wanted someone else to hear my frustration.
Well, look, I would say that if I was a real estate agent in Philadelphia area or greater Philadelphia area, interested in probate, I would reach out to you and try to find some probate opportunities that not only you could either uniquely understand, hey, I get there's a court confirmation, but I know what that means. I understand that process in a way that other investors might not, as well as create an opportunity for them to make some more money. So we'll put that to my community as well.
Okay.
Andre, it's been great. So here are a year later, and you've left the court. So where do you think we have our next episode a year from now? Where are we going to see you?
I think I'm still going to be where I am now. Maybe the year after that, probably have my own firm.
Well, I look forward to that day when that happens. If we can help in any way, we want to generate some business for you. So make sure if and when that day happens, check back. We'll hit our network and try to get some hungry agents to bring you some good probate business or estate planning business or whatever we can. Okay.
Sounds wonderful, Bill.
In the meantime, if someone get a hold of you, what's the best way to reach you?
So my name at gmail.com. So andredesir@gmail.com. That's my email. I've had it for 20 years. I'm lucky. I check it religiously.
Fantastic. Well, Andre Desir, it's always a pleasure to chat with you. Thank you for the update. Look forward to hearing great things from you going forward. Thanks so much.
You're welcome, Bill. It's always a pleasure.